start, that we don't have too much time. We already are in delay. I'm Daniel Guagnin, and I have the honor to chair this panel today. I'm at the Center for Internet and Human Rights in Berlin. I won't talk too much about me. We're just doing research on internet and human rights from very different disciplinary perspectives, so it's quite interesting to have also here quite different perspectives on the issue of data protection and privacy. So first of all, let me introduce Laima Jančiūtė. She's a political scientist with a focus on privacy and data protection, and yeah, she will talk about the European Data Protection Board with the question, is it, sorry, I can't read my notes, so I just give over to you because we're really in a hurry.
Okay. Shall I just go?
Is this you working now? Then you can use this one here.
I think I'll go.
Okay.
No,
Okay.
the clicker. The clicker.
The clicker?
Oh, I thought that.
Next to your hand? Yes.
Am I not there? Am I not
Sorry.
I don't think so.
Okay.
You can speak it.
there? Oh, okay.
Sorry, shortly. And the presentation is about 20 minutes. And yeah, we're happy to have questions afterwards.
Okay, so good afternoon. Thanks for having me here. My paper seems to be a bit of a black sheep among other.
Okay, we messed it up.
Among other techno-legal papers, and but I hope that you are going to enjoy the next 15 minutes or so in the world of the EU politics. So this paper has just been published by International Data Privacy Law, if you're interested. So I would like to start with a few rationales why this research was even born. So first of all, I was quite intrigued regarding the very question of the absence of a fully fledged EU data protection agency, given the whole prominence of this area now, and also the nature of issues like massive cross-border data breaches. Another thing is that, differently from the original proposals, EDPB was granted legal personality and certain limited legally binding powers, and that made its institutional status a bit ambiguous, and it prompted some discussions as well. Also, when before the data protection reform started, the European Commission, as one of the options in its impact assessment, considered significant cross-sectoral centralization of data protection governance at the EU level, and also a creation of an agency, but this option was not pursued because the Commission saw that it would be politically very difficult to achieve, and it would bear enormous costs to create an agency, and the initial aspiration was to get this reform passed before the 2014 European Parliament election, so it was not possible, such goal. And another thing also, that institutional aspects and EDPB, the design of EDPB, one-stop shop, and consistency mechanism caused one of the major deadlocks in the Council in the second half of 2013 during the Lithuanian presidency, and it posed an uncertainty regarding the entire reform, data protection reform, because the European Parliament elections were approaching. So what's about the EU agencies? The EU agencies are separate, they operate as separate entities to help implement EU policies and to support decision making. But when we start talking about them, so we're stepping into a very messy universe, because their landscape is very eclectic, and there is no well-established legal or academic definition. There are no bespoke treaty provisions explaining their institutional place. or how the powers should be delegated to them. As early as in 1950s, the Court of Justice also ruled that only strictly executive powers could be delegated to them, but not discretionary powers, although the later case law seemed to soften that position. Then the EU agencies are also have been created based on different legal bases. And for example, if we think of two agencies that are relevant to data protection policy area, so for example ENISA, which is now called Cybersecurity Agency, until very recently had a non-permanent mandate, and Fundamental Rights Agency doesn't have any legally binding powers, so they are already very different between themselves. But even though, it's not that anything goes, and there are other structures as well, such as regulatory networks that also help to enable pan-European administrative coordination and information exchange. And we have a prominent example here in the field of data protection again, the former Working Party 29, which functioned as an advisory body made of mainly of data protection authorities, national data protection authorities. And to make this already complicated picture even more complicated, we have also other things around, such as other small bodies, non-agencies, as European Data Protection Supervisor, for example. And we also have so-called structured or enhanced networks that acquire some more articulated elements. So with a bit of a spoiler, I will say that this is where exactly I would position EDPB, the European Data Protection Board. And to have a better idea what I'm talking about, we can think also of an equivalent body in the telecommunications sector, which is BEREC. So creation of agencies has never been an easy exercise in the EU, because a lot of different interests collide, a lot of different actors are involved. So often the fundamental choice between the institutional design, whether a more centralized body needs to be established or a much looser network of national regulators, is determined by political dimensions rather than by functional considerations. And the factors that matter here are sovereignty concerns, national politics, distributional costs on the political economies of member states, and interinstitutional contests of power. And it was observed that in some EU policy sectors, the creation of regulatory networks took place only when another option, such as creation of an agency, was rejected. So when we have these situations, such two-level regulatory networks, they are predominantly intergovernmental in nature, even when they deliberate at the EU level, and they embody the limits to supranational institution building. And when we have these strange situations where there is an obvious need for more for a more consolidated functional action, but there is no desire to let go one's own competences and powers, so we sometimes come up with rather strange structures that function in a strange way, and I immediately can think of the fact that now the Secretariat of EDPB is provided by the European Data Protection Supervisor, but under separate reporting lines, so it's pretty strange. And when we have these situations, so we need to think about nonlinear, two-way EU integration dynamics, and that brings us to state-centric paradigms on EU integration and intergovernmental aspects, and principle of subsidiarity, which warrants the autonomy of member states against excessive expansion of EU competences. So next is going to be a very basic overview of a very complex and lengthy process. that took place during the data protection reform that was launched in 2012. And rather than on procedural aspects, I'm going to focus on political aspects. So just to recap briefly, when the GDPR proposal was tabled, as an institutional reform and consistency mechanism, Commission proposed a more structured DPA's cooperation mechanism, one-stop shop system as one single interlocutor data protection authority for multi-country operations, so-called lead authority, upgrading Article 29 Working Party to the EDPB, adding also, apart from the advisory role, adding also consistency opinions and steering, facilitating the overall cooperation of data protection authorities at the EU level. And also, Commission had designated itself a backstop role in that mechanism. It wanted to take, to also issue opinions when it disagreed with draft measures by the competent DPAs, to issue opinions of which they had to take utmost account, and even to suspend those measures sometimes. So that was set to be altered substantially, and this ultimate decision-making power of Commission was removed. So the major problem took place in the Council, because member states, although they endorse in general such idea of one-stop shop, they were not happy about the concentration of corrective powers within the remit of the lead authority. They wanted also their own, the data protection authorities of their own countries not to lose the legal standing when data subject of respective countries were involved. So various alternatives were floated. Some countries were quite in favor of a robust, stronger body, such an agency, for example, Germany and Belgium. Then in contrast, France was proposing a co-decision model when all concerned data protection authorities would be involved at all stages of processing. So none of these things found support, and as a trade-off to secure some sort of credibility of new enforcement arrangements, the decision was made to introduce limited legally binding powers by the EDPB when there are disputes between the DPAs, the lead DPA, and the other concerned DPAs. So this limited dispute resolution mechanism was foreseen in such scenarios as conflicts as to the identification of lead DPA, conflicts as to the functioning of cooperation between DPAs, mutual assistance or joint operations, conflicts as to the merits of one-stop shop draft decisions, whether there is or no an infringement of the GDPR, and conflicts resulting from failure to ask or to follow the opinions of the EDPB in cases subject to consistency mechanism, such as binding corporate rules or codes of conduct with cross-border impact. So these scenarios were later enshrined in Article 65(1) GDPR, but the substantial discussions took place to prevent the over-referrals to the EDPB of cases, so it had to be an exceptional measure, these binding decisions. And as the documents of the Council state, there was the EDPB, it was necessary to exclude that the EDPB would substitute itself for the lead supervisory authority, or would become a de facto EU-wide lead authority or DPA. So it was also stated that the EDPB decisions should not preempt any application of national law where national law is relevant, such as, for example, on freedom of expression or employment law. and it should be limited to the interpretation of an application of the regulation. So in terms of other institutions, European Parliament in its position also was in favor of binding decisions in individual cases when the EDPB was objecting to the final draft decision by the competent authority, and it also diffused the decision-making powers of the lead authority by making the consultations with other competent authorities mandatory, and by allowing them to object to the handling of the case by the lead authority. Instead, the Commission was defending its initial idea of being a backstop, and it didn't approve the idea of the EDPB's legally binding powers as not having also legal basis, and Meroni, the earlier mentioned Meroni law case law is relevant here, was also brought up. And it also reiterated that creation of an agency was not an optimal solution because it would require enormous costs and time as well. So in terms of DPAs and Working Party 29, in 2009, they say in a document they stated that actually the working methods and the commitment of the members of Working Party 29 had to be improved, and so that collective decisions, opinions are implemented better at national level. So they endorsed legally binding powers, the idea of legally binding powers by the EDPB, but as exceptional last resort measure. And they saw, however, this body as a decentralized network of independent authorities and not a centralized structure. And the idea was distributed governance. And in terms of another stakeholder, European Data Protection Supervisor, said that the idea of an agency was conceptually tempting, but it would not optimize the decision making within a reasonable time limit, and it would also change the existing decentralized system into a more centralized mechanism. So the result of this whole process was what I would term as a qualified one-stop shop, where the data protection authority of the main establishment would act as a single interlocutor only for the cross-border processing operations, and local DPAs remain competent if the subject matter relates only to the establishment in its member states or affects data subjects in its member states, in respective member states. And for example, Professor Locke Morel from Tilburg University thought that CNIL's decision finding Google a year ago, when it didn't switch to a one-stop shop, actually violated the principle of one-stop shop. So it was very interesting to come across in a report by EDPB 1 year ago, across the statement saying that EDPB does not deal with cross-border cases unless there is a dispute or a case of urgency. And even though it looks like it is stating the obvious that follows from the GDPR, but I can infer a political message here, like showing the place of where is the place of certain actors, and even more so, it makes me think even more so because I came across, for example, a quote in Politico by Irish Data Protection Commissioner Helen Dixon, which stated that it's not the responsibility of the EDPB to take over the role of national data protection agencies. So it sounds quite political to me. So just the core highlights where we stand. So even though EDPB has been endowed with legal personality and certain limited binding powers in exceptional circumstances. As we know now from the overview of the process, the creation of an agency was not intended, and this option was rejected. And even though the Secretariat is provided by the European Data Protection Supervisor, and there might seem to be some sort of merger between the two dimensions, national and supranational, but as I mentioned earlier, there are different reporting lines. Also, the very Article 68.1 establishing the EDPB refers to it not as an agency or authority, but a union body. Then the EDPB's permanent vice chair mandate was removed, which was proposed by the Commission in the original draft, and I would term these as non-radically supranationalizing elements, but even those were removed. And also, European Data Protection Supervisor was granted only limited voting powers in the newly introduced data dispute resolution mechanism, only in those cases where they are relevant to the processing they can be correlated also to processing of processing within the context of union institutions. Another thing is that cross-border cases do not automatically go to the European Data Protection Board, and also the DPA's representative continue to reside and work in respective countries. So it's network structure. So the last slide. So do we need to have an EU data protection agency? So the former European Data Protection Supervisor Giovanni Buttarelli thought that actually we would benefit from a different, from a more robust body, but he saw this as a longer-term perspective, maybe in 10 years' time. And in some of his speeches, he made also some allusions to the U.S. Federal Trade Commission. So some recent studies have argued that in many policy areas, tangible added value has been derived from a more cohesive EU-level actions enabled by the EU agencies. And when we have regulatory networks in place, we basically need to think about opting for a greater flexibility and the lowest common denominator instead of adopting a harmonized approach. And finally, if we think that the very GDPR, the law establishing the EDPB, was adopted with circa 50 derogations, so it clearly shows that the terrain for creation of a more robust body was not mature yet. Thank you very much.
Thank you very much. Do we have a short question to that? Otherwise, I would maybe shortly ask if you, in conclusion, want to give an opinion. What would be a functional cooperation, or in alternate, or if you have an idea how the relation between the agencies will develop.
Which agencies?
No, I mean between the
data protection authorities.
Yeah.
So basically, my research and my work on this paper and my reflection was focused not on functional aspects but on political aspects. And speaking of political aspects, so like I said, this had to be a very basic and brief presentation, but my paper is more complex and there are a lot of things discussed. So I clearly show that there's little desire from the national level actors to give up their domestic competences and to delegate powers. And also, yesterday there was a good session on good panel on the one-stop shop, and various stakeholders also voiced their view that there seems to be really little appetite for now, as it seems now, for more cooperation and for switching into one-stop shop.
Okay, thanks. So now I realized during the presentation that it's quite hard to see the
Yeah,
slides. So
sure,
if you
yeah,
want to
there's
stand up and go to the computer, that you can see it better.
Can't
maybe.
we move that one a little bit otherwise? Because I'm too short for this. Sorry. Just a little bit.
Yeah. Now.
Oh,
Yes,
terrific.
yeah, I'm
Thank
sorry.
you.
Yeah, or you can also.
I'm
go.
fine. Now I can see. Thank you.
So now we listen to Silvia de Conca from Tilburg University. Yeah, just
Is it
go on.
already there, or do we have? Yeah, no. No, not mine. Sorry.
So I can go on with introducing her. She's working on the effect of vocal assistance on the private sphere of customers.
Yes.
With a legal perspective in her PhD work. Yeah, and now go on.
Thank you, Magda. So I'm a bit of an intruder here because I'm actually not a senior academic, but as long as you guys don't notice, I'm gonna make myself comfortable, so thank you for having me. So what I'm talking about from the technological perspective is these. I don't know how many of you recognize them. These, one is Alexa, or well, it's actually Amazon Echo. Alexa is the assistant that powers it, and Amazon Echo is the speaker part. And the other one is Google Home, whose assistant is called Assistant, Google Assistant. And they can operate a series of apps or devices connected to them within the household environment, you know, smart homes, etc. And they can be used for several tasks, from listening to music, getting the news, getting the weather, activating smart locks, smart coffee pots, smart TVs, smart mattresses, toothbrushes, Christmas lights, infinite amount of devices, really. This is more or less the kind of ecosystem that I am studying, where you have the humans, the device, which is installed and activated through an app on the phone, and then is usually provides for vocal human interaction. And then the different, up on top of the house, the different devices that can be connected to them, and apps, which are called usually skills or actions. And they are the little softwares that, just like an app on the smartphone, allows you to have some functions, some skills. Now, the main actors here are the producers of the device, of the main assistant. So the two most famous, sharing 75% of the market at this point, are Amazon and Google, mostly Amazon. Then we have the third-party app and or devices producers. And then we have the owners, which are also the most frequent users. On the other side, for the law, in particular for the GDPR, we have the well-known controllers, processors, and data subjects. Now, we know that producers are controllers and can be processors. We're going to see why. Third-party app are most likely joint controllers and can be processors. We're going to see how. And owners are obviously data subjects. But, and here there is a big but, they can also be controllers potentially for the law. I'm not saying they should, I'm saying they could. Vis-a-vis the data of the guests, temporary guests that they have in the apartment. So now, today I want to focus briefly on what can the condition of the controllers be, and the one of the third-party app and product developers. So owners, we know they're data subjects because, well, if they're using the device, they are, because they are the very well identified person which talks to the Alexa or the Google Assistant and has a profile and a voice profile to be recognized. Can they also be controllers? Primary controllers are definitely still going to be Amazon and Google. No one is discussing that. Additional co-controllers are most likely the third-party developers. Control, for the GDPR, most of you know, is determining the means and the purpose. And even if a party controls the means and the purpose. If the household exemption applies, actually they are controllers, but the GDPR will not actually apply, and the obligations of the GDPR. So what does determining the means and the purposes means? Oh, English. It's a de facto determination. So even if someone claims they're not controllers, if factually they determine the means and the purposes, they are still going to be. Determining the purposes, according to the Article 29 Working Party, automatically makes you basically a controller. Determining the means only makes you a controller if those means imply having control over essential elements, which the Article 29 Working Party doesn't specify, if only for which data are processed and for how long. And then they leave it open on which can be essential means. So it's a bit ambiguous already. However, the court has already decided very recently with the Wirtschaftsakademie, terrible German, I'm sorry, and the Fashion ID case, that being a facilitator and also partially benefiting from processing makes you a controller only for usually the initial stages. Being a facilitator means enabling the data collection. So opening a Facebook page, putting cookies on your website, which is the case of these two proceedings. The court has also already established that not having availability of the data does not exclude control, and that control is not the same for all the parties that are deemed to be controllers. There can be different degrees, different stages in which you're controllers. So there is an approach of somehow breaking processing into stages and parts and seeing to which degree each part is a controller. I am simplifying, so. And again, this is all unless the household exemption applies. So let's see, the household exemption, first of all, can only be natural persons, purely personal or household activities, usually correspondence or managing a family or a house or your own private matters, as ambiguous as this is. Location doesn't matter, we have discovered with the Reynes case, because if you have security cameras or sensors that are from within the house pointing outside of the house on common areas or public areas, the household exemption no longer applies. And in terms of purely personal or household activities, social networking is now by the GDPR, by Restyle 18, considered actually usually to fall within a purely personal purpose, unless, obviously, you're acting on behalf of a company, because at that point you have a business activity or an association, doesn't matter if it's a charitable goal or not, but basically as soon as there is a lucrative purpose, what the traditional law would call. And here it gets very tricky, if you have an open profile or a profile with a lot of contacts, and the Article 29 Working Party doesn't say how many is a lot, then the household exemption with social networking activities might not matter anymore. And the reason why I'm specifying this is because through Alexa and Google Assistant, you can actually manage your social network accounts. So some of the apps actually are provide for social network activities. So potentially, we can have that an owner of an Alexa or of an Google Assistant powered device can be a controller vis-a-vis the data of the guests that are temporary in the house, because he might be considered, or she might be considered, a facilitator, enabling the collection of the data. However, it depends on how we interpret determining the means, determining the purposes. Is choosing the app or simply activating the device and not pushing the mute button enough? This is not clear yet. And it's also not clear if we can consider determining the purposes, the fact that the controller wants to listen to music and meanwhile talk to their guests. And since Alexa and Google Assistant are going to record and stream every sound that occurs in the room while the music is being played, is the data collection really necessary for the determined purpose of the controller, or does it even matter for the GDPR? This is still not clear. With regard to the household exemption, we can assume that on a lot of the functions of Alexa and Google Home, it will apply. But social networking activities, we don't know yet. It's not clear. And there is the problem that these sensors, and cases have already happened, actually can also record things from outside of the door of the apartment or nearby apartments. There was the very funny case of a guy that actually activated the thermostat of the neighbors through vocal interaction so that his house was actually warmer until they introduced voice profiles. So we don't know yet. And obviously, if the device is used for business purposes, imagine a fashion blogger with Eco Looks, which is a device connected to Alexa that allows you to take pictures of your clothes, then the household exemption doesn't apply anymore. So yes, they can be potentially controllers. Personally, I believe they shouldn't be considered controllers, and we should apply, and we should not apply an extensive interpretation of determining the means and purposes, or in any case, we should then apply an extensive interpretation of the household exemption. Because the law does not deal well with burdening a party with an obligation, and the party doesn't actually have any means to comply with that. If the guest that is the data subject asks the owner access to the data are with Amazon. How am I going to give them access? I can only mediate so that they can have access. The risk of fragmenting obligations, in this case, I think would go to the advantage of big corporations like Amazon, and I don't believe that what the late Advocate General Bott said about the rippling effect has been proved. Maybe it will. I also think that if I have a problem with my guest that doesn't want to be recorded, I can follow the informal rules and guidelines suggested by the producers like Google and the Article 29 Working Party that say, use the mute button, inform your guest, ask them if they're okay with that. And if that doesn't work and there is a damage, the law still has extra contractual liability to deal with that. So the data subject would still use the GDPR with the primary controller, which would still be Amazon or Google. And if I still have a problem with my friend that has it, maybe I can have a way through extra contractual law. However, the complexity is not over yet, because we also have the producers and developers of third-party apps and devices. They can be controllers. We've seen what makes a controller. And they can also potentially be processors. But to develop an app or a device, I need to use an API, which is a system to basically program in a way that is immediately, it's an environment to program in a way that is immediately more compatible with Alexa or Google Assistant. The API is provided exclusively by Amazon and Google, and the developers cannot modify the API, can only build on top of it. And they have to sign to the terms and conditions of the API. Now, the terms and conditions often already establish which devices they can use or for which purposes. So in terms of determining the means and purposes, the moment I have an API that I cannot tinker with and I have terms and conditions that I have to respect, it's already a bit shaky. As an additional layer, developers might borrow lines of code from other third parties, fourth parties, libraries on which they can be very opaque and on which they can have zero control, and that might enable data collection in favor of the fourth party. At the same time, as processors, if they have a controller-processor agreement with Amazon or Google, we can assume they are processors. They might still be de facto processors, but definitely not on the basis of the terms and conditions. I have read them all, several dozens of pages, and they do not integrate the requirements that the GDPR imposes for an agreement to be a controller-processor agreement. And at the same time, the API embeds web services provided by Amazon and Google, for example, cloud storage. For those web services, Amazon and Google are actually the processors. So we have this extreme complicated scenario where there can be co-controllers For some very small parts of the processing, the third party can be the controller and Amazon or Google can be the processors. From some very interconnected parts of the processing, it's the other way around. And the integration of this service is really, really strict, and it's very opaque. So the thing of breaking the processing into parts might actually complicate identifying exactly who is controller and processors. Now, I am not saying that third-party developers should not be co-controllers. They definitely process data, and most of them benefit from them. But there is a power asymmetry, there is a technological asymmetry there, and in terms of proportional obligation deriving from there, I think we have a hard time unless we just go for chopping really big pieces of obligations and assigning them to parties. And at the point where we have Amazon or Google being processors, while at the same time they're also controllers, where at the same time the third party is also a processor and a controller, I think we're going to have a serious hard time. Because, as I said, there is complexity, there is mutual technological integration, and the business model is not facilitating discerning who is doing what. And the concrete users might add the layer of the owner. So do I have an answer on how to assign them? Absolutely not. But I think that if this goes in front of the European Court of Justice, we're going to have a lot of fun trying to figure out who's doing what here. Thank you.
Are there questions in the audience? Otherwise, I would quickly ask, you mentioned the household exemption, and if I think of Siri and OK Google, it's devices we have in our pockets. So if I'm standing in the queue or in the bus, should I inform all the people around me?
Yeah, and again, we have layers of complexity here. From an abstract perspective, the phone in our pocket has been considered already before a ramification of the home. So definitely we are blurring a little bit the private-public boundaries here. OK Google, as a matter of fact, is Google Assistant.
Yeah, but you also have Google Assistant.
Yeah, because they're supported on different devices. So you can also have the fridge that supports Alexa, and you don't even need the Amazon Echo, right? So the one you have on your phone is exactly the same assistant. It's one single brain in the cloud. So this is why I believe that we actually need to find basically some common ground social norms of politeness here in dealing with that, because I agree with you. Am I supposed to do that if I am activating it on a train? Should I activate it in public at all if I know that someone else might be? So we need to find a way around this. Or I don't want to be the controller of someone standing next to me on the bus. Definitely not.
Yeah.
Thank you. I have wondered whether your ultimate conclusion after all this research would not be that maybe we should simply reconsider the concept of controller and processor and the existence of these two concepts, because they're not entirely new, and as we see, the reality is so much different from what the law says.
Well, I'm not a punk in that sense. I don't want to see the world burn, and I definitely don't want to see the GDPR burn. I think it makes sense for the law sometimes to work with approximations, and we've done it since the dawn of the law. And we also have, forms of responsibility appointed to subjects, even if they don't necessarily match the reality. What worries me is that what worries me more is this tendency to break the processing, and based on that, assigning the roles. Because it works very well for certain things. It worked better before when there was less complexity in integration of systems. And I don't know how long it's going to be sustainable. So how long it's going to keep working for actually assigning responsibility. And I don't know to what extent it's going to start creating loopholes that then the primary controllers and the primary persons responsible might take advantage of. And honestly, I don't have an answer or an alternative to that. But that might become problematic if we keep integrating.
Maybe we, short, very short.
I was just wondering, because you were talking about APIs in this specific context, if you have looked at APIs in general, because I guess the problem is the same in any context. Like if you take Facebook login service provider to all websites, they also make use of the API, they have to follow the rules of Facebook, etc. Still, they decide to use the service. So, yeah,
yes.
Your thoughts on that?
Yes, and it's magnificent when you have an app that has to work at the same time with the API of Facebook and the one of Alexa, for example, and then the one also of another device. And yes, I honestly believe that third-party apps and device producers can be free riders and can be extremely malicious, but they can also be in an extremely, like when they're not malicious, they can be in an extremely weak position, and I am not fully comfortable with the idea of assigning them full of GDPR obligations, because I don't see that proportionate with the amount of control they actually have. The granularity of control that the Article Working Party wishes for processors, I see that it shakes here a little bit.
So let us quickly go on. And the interesting thing is that it's not only on our conversations, it's also all the data which is stored on our phones, which is at stake in a way. And again, we have a strong asymmetry. So now we have the yesterday awarded paper for privacy the award for best privacy protection awarded paper, which also led to an open letter to Google claiming that there's this asymmetry between the phone manufacturers and its users. So I'm happy to give you the word.
Thank you. So I wanted to start with a small question for the audience. How many among you are using an Android device or ever used an Android device in your life? Show of hands. So okay, so pretty much everybody. So okay, so it won't probably surprise you to learn that Android is actually open source, meaning that anybody, any company can take the source code and modify it before selling you your device. And I'm not going to go into the technical details, but what happens mostly in practice is that they add a bunch of new applications that they pre-install on your device to add some feature or to add some market value, and that's supposed to make you want to buy the device in the end. And in our work, we focused on those system pre-installed applications for the following reasons. Basically, they are privileged by the system, meaning that a pre-installed application is trusted by the system because it's in the system partition. It can get access to some APIs or some personal data more easily than a user-installed application because it's installed not by the user but by a company sometime in the supply chain. They can run in the background without user interaction. In fact, some of these applications don't even have a user interface. They are still there, they're still doing something. You don't see it, but it's still happening. And the last one, the most frightening one, is that they cannot really be installed. I mean, you have your device, you can probably manage to remove some of them, but it's technically difficult, not always possible, and you might just break your device on the way and end up with a paperweight instead of a phone. So what's interesting also in those applications is the diversity, which in fact reflects the diversity of the supply chain of Android devices. There's a lot of different vendors, a lot of different manufacturers that all have different partnerships and chipset manufacturers. So if you take two random Android devices, they might have gone through a different set of companies along the way between the design of the device to the time you actually boot it up for the first time. And each of these companies along the way, along the supply chain, have the possibility of actually pre-installing some extra application on your device. And it's not all, because they all have also partnerships. And they can also allow their partners to also pre-install some application on your device. Some of these partners have very data-centric business models. Now, Google is aware of this project, of this problem, and created a certification for vendors, phone vendors and manufacturers. Basically, to get that certification, you're supposed to answer a few questions about your business, and then supposedly, because it's not actually public what they do, but you're supposed to send the device and then test it to assess the security and the privacy of this device for the users. Now, this is not clear exactly what they test, and it's not exactly clear when they test it, at which point in the supply chain they test it. So we don't really know what exactly do they do to decide if a brand is worthy of the certification or not. And in fact, there's some anecdotal evidence in the press that show that it's clearly not enough. I mean, this is just a bunch of headlines I found in the press. This one is about undercover journalist who've been working in a country that does not really respect human rights and got her identity blown up because of a pre-installed piece of software on a phone. There was this piece on the Wall Street Journal about very cheap devices, like $40, $50 devices, riddled with pre-installed application designed to harvest user data to then sell to marketers. Or backdoor, actual malware coming pre-installed on some devices, and this has been confirmed by Google. And finally, the one that made a lot of noise a few years ago is Facebook having partnerships with big device manufacturers, like Samsung, for instance, to pre-install the Facebook application on the system so that they get access to contacts and all sort of user data. So based on this, we wanted to take a real deep look at the ecosystem of pre-installed application and answer a very simple question in the end. Who pre-installed applications on Android devices, and what does these applications doing, and what can we do about it? So the first step in this project was to actually get access to the data, because most of these applications are not actually public. So the only way to get access to these applications is to go and buy a device and then copy everything you find on a system partition to your computer so you can run some analysis. Problem is, what device do you buy, right? And there's so many different vendors, and if you buy all your devices because you have a lot of money, you buy all of them on Amazon, then you might miss some applications that are installed by some brick and mortar shop. So you cannot really get all these applications just by buying devices. And our approach was different, was to rely on crowdsourcing mechanisms. So we developed an application that is freely available on Google Play. And when you install it, it scans your system partition, and every application that is pre-installed and that we do not already have on our server sends that to our server. Of course, we take great care of first getting user consent. We explain what we do and why we do it before harvesting any data at all. And we do not take any personal information, just some anonymous metadata about the device. So with this data collection, we managed to get almost 82,000 unique applications out of 1,700 users, so devices, covering more than 200 vendors on over 130 countries. So we have a very broad view of the whole pre-installed application ecosystem. And armed with that data set, we managed to answer some of the questions and raise some others, actually. So the first question we wanted to answer is look at the supply chain. So look at who pre-installed application, who developed this application, and who put them there, and at which point in the supply chain. So this is going to be a bit technical, but please do not be scared by the next slide. So in Android, application must be digitally signed. You don't have to know what a certificate is, but just know that in every application there is a digital certificate that you can use to identify the developer of the application. It looks like this. So this application is named com.google.uid.shared. I don't really know what that does, but it seems to be from Google, right? And the certificate says it's from Mountain View, Google Incorporation. Okay, fine. So based on this, you can say, okay, this application is from Google. But we have other applications, this one, with a different certificate that also says Google. But in that case, the package name is com.ppswipe.brew-rewards, and it's actually collecting a massive amount of user data. And we're pretty sure it's not Google, but we cannot really be sure. And we cannot really be sure that the previous application was also developed by Google. And it's even worse if you look at the whole data set of application. In fact, we found more than 92 unique certificates that claim to be from Google. Some of them are probably from Google. I mean, if you look at the YouTube application or Gmail, it's probably Google signing this application, but for others that may not have a user interface or may be a bit more hidden in the system partition, we don't really know. And we have no way of knowing for sure if any of those certificates are actually belonging to Google or to some other company or some guy developing malware in his house. And the same goes for all the other companies. And So the top 5 are actually phone manufacturer, but if you remove those and you look at the others company, you find some lesser known company, such as MediaTek, which is actually chipset manufacturer. In that case, it makes sense that they provide some application because, well, they actually do the hardware. Maybe they need to provide some software to interact with it. But in some other case, we have, for instance, Verizon Wireless. Why do we have 10 certificates for Verizon Wireless in pre-installed application on phone from all over the world, right? And in some other case, we don't even know. There's no indication on the certificate. Sometimes it just says company or China. And based on this, you have actually no way of knowing who actually created this application. And this is one of the first point we made in the paper, is that there's actually no way, based on just getting the applications, to know who put it there and who developed it, which is already a great concern for users' privacy and security. Now, in the supply chain, I talked about partnerships, and sometimes the way these partnerships are present is to third-party libraries. We found many third-party libraries in pre-installed application. Some of them in very legitimate use cases, such as a development application or for cryptography, for instance. You do not want to write it yourself, so you use one on third-party libraries and integrate it in your app. But we found also hundreds of third-party libraries actually belonging to companies that do advertisement or mobile analytics that are very data hungry for their business model. And they are present in thousands of applications, or pre-installed applications that, again, you cannot remove. And this begs the question of user consent, because you buy a phone, right? We can assume you want to buy that phone, but you don't really know what's pre-installed on that phone, and you don't really know which company get access to your data through pre-installed application or third-party libraries. At no point do they stop and ask, hey, do you consent to this data collection? So this is already worrying because we have a lot of applications, but we don't really know who put them there. And we try to answer the second question, which is what they're exactly doing. Because we have the code, we have the application, so we might be able to understand what they are doing. I have to explain very quickly the permission system on Android, because in Android, some resources are actually protected by the system, such as your geolocation or your contacts, which means that an application cannot, by default, get access to this information for obvious reasons, for privacy reasons. Now, if an application wants to use the contacts, for instance, for a legitimate reason, the system will display a pop-up like this saying, hey, this application wants to access your contact. Do you agree or do you not agree? What developers can do, and what they do a lot on pre-installed permission, is use custom permission. So instead of relying on the official permission system that is protecting the user's privacy, they can create their own permission to basically expose some kind of API in their application. So I have a piece of my application that I want to make available to other applications on the phone, and I use a custom permission to protect this, to restrict which app has actual access to this service. For instance, the Baidu location service, we assume it's coming from some Baidu application that implements some kind of location service, and other application on that phone can request that permission, and without any user interaction, interact with the Baidu location service. So it's a way of, in some cases, escaping the permission system in Android to get access to whatever. We found almost 5,000 unique custom permissions in a dataset, which is huge. And we manually classified them to try to understand who do they belong to, because in some cases, such as Baidu location service, it's quite obvious that it probably belongs to Baidu. But in some cases, it's not possible. In fact, almost 4,000 are belonging to vendors, phone manufacturers. For 10% of this permission, we're not able to map it to any company, which is very worrying. And even more worrying, we found those custom permissions in core Android module. And I'm talking about the system user interface. I'm talking about the phone application, the contacts application that you will not remove even if you were able to remove any pre-installed application, because those are applications that you actually need and use every day. And it's very worrying that this application are actually implementing extra feature without the user's knowledge, and we don't really know what those features are. We just know they probably exist because we see those custom permissions, but we don't really know what they do or why they are there for. Now, with those custom permissions, we can also try to reveal some partnerships between companies. And you don't have to try to read this because it's way too small. I'm just going to zoom on 2 of these lines. The first line is MediaTek, which again is a chipset manufacturer, so it has a lot of partnership with phone vendors, which again might make sense because they provide the hardware. The bottom line is actually Facebook. We have found a lot of Facebook custom permissions in pre-installed application from many different vendors. And it's actually a good way for Facebook, but for any company to get access to millions of users, because if you look at this line, for instance, this line is Samsung. And Samsung has a lot of partnerships with a lot of different companies, because if you, as a third-party company, you manage to get pre-installed in Samsung devices, you instantly touch millions of users. And easily, because you don't have to convince them to install your app, you don't have to convince them to use your app because it's already there, and whether they want it or not, it's going to do stuff. We also looked by automatically analyzing the code as the pieces of personal information that may be accessed by the app. This is static analysis, so we do not execute the app. We just look at the code and say, yes, this app is technically capable of accessing this piece of data. Doesn't mean it does it, but it can do it because the code is there. And I'm not going to go over the whole table, but in this pre-installed application, they're able to access unique identifiers from the user. They're able to access the system logs. Some of them are able to execute Linux command directly on your phone. I mean, you don't have to be a technical person to know that this is a huge security and privacy risk for users. And even worse than this, because yes, it gets worse, we actually found malware, non-malware sample pre-installed on some phone devices. And also, so routing application that you can use to get complete access to the phone, or engineering mode apps that are used in a factory to test that everything is working fine is supposed to be removed before shipping it to the user, but in some cases it's not, or blockers. By blockers, I mean phone numbers blocker, by SMS or call, or even domain blockers. So we found many more of these kind of application, and there's many more details in a paper. If you're interested, I encourage you to go and read it. Now, based on all this, the question we ask ourselves is, okay, what do? We have lots of applications developed by somebody, we don't know who, they are doing something, we are not quite sure what. What do we do from here? Where do we go from there? So, well, you talked about it in the introduction, but the first step, I think, is to raise user awareness about this issue. And Privacy International is actually running now a petition on pre-installed application based on our results. This is a great first step because I think that can make users aware that this is actually a thing that actually happens right now on their devices. And well, Google obviously can do something to change the state of affairs, and they seem to be working on it. And by they seem, I mean, I don't really know what they do because they don't publicly announce it. But these are 2 tweets from 2 different researchers from Google that are now doing talks on pre-installed application, how to analyze them at scale, or on the supply chain analysis of Android devices, which is great. We need Google to actually do something about this because they have a central place in the whole Android ecosystem. But I don't think that would be enough to just rely on Google. We came up with some recommendations based on what we've seen in our data set. And the first 2 are actually quite simple, is just to document and improve the transparency and everything. I was talking about certificates. We have 92 certificates that claim to belong to Google. Google could just come up with a simple web page saying, hey, these are our certificates. All the other certificates that claim to belong to Google are fake, do not trust the app. And that would be a huge step forward already. And it's at almost no cost for Google because there's no security risk for them. The documentation of custom permissions and APIs, because as of now, we can find sometimes, in some specific cases, some documentation about custom permission, but in the overwhelming case, there's nothing. We find sometimes some pieces of code somewhere on the internet, but that's pretty much it. Now for regulators, I don't think regulators are really aware of the extent of this issue, and I believe that they could, we could use some stricter policies on what gets to go on a phone and how do we actually control all of this. I will let the regulator debate on how to actually implement this and everything, but this is something that I believe we really need right now to kind of force not only Google, but all the manufacturers of devices to actually do something to improve this ecosystem. And well, the last one, I put it again because to me it's the most important one, is user awareness. Simply put, if users don't know, they won't care. And we need to make users aware that this is actually happening. Well, that's the end of the talk. Right now, what we also need as researchers is help. We need more research going on this, both from a regulatory perspective, but also from a technical perspective. And to try to help you get into the game, we're actually releasing some data. You can go on that link right now and get some metadata only about our data set that we use for that paper. You have the certificate information of the application as well as the fingerprint of the device on which we found them. So I encourage you to go and play with the data to try see what you can find. And that's it. So thank you very much.
Thanks for the presentation. Do we have short questions?
You mean, do we do any vulnerability analysis on the device? Well, technically it's probably possible, but that would take a lot of power from the device, and it's better to just extract the application and then do some analysis on the server that has more power and everything. But I guess that would be possible to do so. We have found some vulnerabilities that we need to report. The problem is, in some cases, we don't know who to report them to, because you find an application pre-installed with an obvious vulnerability, but the certificate says company. What do you do? Who do you contact to report the vulnerability? So it's nice to scan for vulnerabilities, but in the end, there's nothing the user can do, right? So as of now, the application just looks for application, and whatever we don't have, it sends that to us, to our server.
But I would say, I think the essential point here is that if we have so many applications installed with that deep level of permissions, there's no backdoor needed, because all the manufacturers of these applications have a front door. Isn't it like this?
Mm. But then if you have a vulnerability, somebody else could use it, and especially since you have a high level of privilege. If I know that a given phone comes with a given app that has this vulnerability, I can then scan the entire internet in hope of finding phones that have and then exploit them. That's why it's also important to look for vulnerabilities, but the problem is, who do we declare them to?
Yeah.
Two short questions. The first one is, you were saying that basically that Android is open source, which is technically true, but practically everybody that wants to provide an Android device is dependent on Google, because they want to have access to the App Store and to other functionality that Google provides. So although it's open source, they would need to do a lot of additional development if they want to have their version of Android that is not depending on Google. Do you think in that regard that maybe there should be more emphasis on the power that Google has in this case? Because if there would be less power or a more differentiated market of providers of open source or non-open source operating systems, like Nokia tried it, or for sometimes there was Firefox OS, that would maybe solve the problem?
So you can actually modify the Android source code, and it's encouraged by Google. That's why if you buy a Samsung or Huawei, already the user interface is different. It's because it's already modified, and then you have extra features and whatnot. And then if you want to get access to Google Play Store, which most vendors want because the user wants that, so you need to get the certification in that case. You need to go through with the process to get the certification, and then you have the rights to pre-install the Google Play Store as well as all the Google apps like YouTube, Gmail, and Chrome on your device. But if you don't have the certification, they don't give you the Google. They don't give you access to the Play Store. So I mean, they do have a lot of power that I don't think they really use it right now, because the certification is officially to protect users' security and privacy-wise, but in essence, from the outside, actually, because I'm not affiliated with Google in any way, but it looks like they use it more to regulate who gets access to the Play Store and not. And since everybody wants to get access to the Play Store, they kind of force you to follow whatever recommendation they give you. But they could do much more with the certification. They have a tremendous amount of power that they're not really using right now. I'm not saying that they should abuse it, but they definitely could.
And the second part, which goes into basically the same way, Wayne, I think it was like 1 or 2 years ago when Google decided that, if I remember correctly, that they doesn't want to let vendors decide if they will allow an upgrade to a new version of Android because of security issues and etc. But some vendors then decided to not comply with it. So for instance, I know that if you have an old HTC, you will not be able to upgrade to anything above Android 5, because at that point they were saying, okay, we would need to comply with more rules from Google, so this is where our support ends. You stay with Android 5 with all the vulnerabilities and open holes it has, and good luck to you. In this case, do you think it would be easier to attribute the responsibility to the vendor, or?
So I'm not sure who has the responsibility for this. I mean, Google does update the code, and it's open source, or the company should be able to take it and adjust it for the devices and then push the release. They don't always do this, but I'm not sure if it's because it's technically difficult or it's because they want to force you to buy the newest device that is more expensive and brand new and everything. I'm not sure it's Google's fault for this problem. I really think, but that's my opinion, that the fault lies with the vendor on that problem.
Yeah, I think we have to stop.
Okay.
But anyway, it's a problem that you don't get updates after a short amount of time, and you can always tinker and build your own system because open source, but that's beyond most probably. Yeah. So thank you for these good presentations. Thanks for the audience and to staying to the end, and yeah, enjoy the evening, the upcoming side events, and maybe see you later at the Mozilla event.